All right, in this video, we're going to go through how to explain the exclusive right to sell to a potential seller in layman's terms. So again, precursor to this video is this is not how to fill it out and the why to fill it out, but this is how to explain it and go through it with your sellers. All right, I don't know why, but Gary jumped, and Carson is not talking to me. He's on the phone. Okay, cool. We're going to go through this. Can anybody hear me?
Yeah, we can hear you.
Sweet. Okay. So in order to start, we want to go through this and we want to understand that everything in blue is everything that I filled in and we're going to kind of concentrate on. Everything in black is all commission based. It's all boilerplate legal jargon that I'm going to explain to you kind of in layman's terms as we go. So stop me as we go, ask me any questions. But to begin, I'm going to be working with you as a seller's agent. And what this means, or the difference between that and a transaction broker, is that I will be your coach in the game, right? I'm going to have your best interest in mind. I'm going to be able to strategize, set up plays with you, negotiate, learn your motivation, what's important to you, and I'm not going to spill that to the other side. If I were to be a transaction broker, what that would mean is I would be the referee in the game, which means I can't call the plays. I can't negotiate with you. I can only give you facts and have you make those decisions. Let's move forward as a seller's agent. I do work for a multiple person firm called Keller Williams. That's where I hang my license. Please go ahead and double check to make sure your names are spelled correctly. And this is exactly the way that you would like to take title. Or I'm sorry, this is exactly the way you guys are on title. This is what I pulled from public records. And so you guys haven't done any name changes or any quitclaim deeds into anybody else's names, have you? Perfect. I gathered all of this from public records. So this is your guys' address, but this little guy up here is called what we call the legal description. Again, this is from public records. This is what we're going to be monitoring throughout the transaction and making sure that we transfer your name on this property into the buyer's name, free and clear of any liens or encumbrances. And this is the legal description in which we'll kind of keep a close eye on, so that way the title company doesn't actually sell the wrong property. Section 3.7, this states that we are going to begin this listing agreement today, and I have it ending about a year from now, or 6 months, whatever you guys want to use. Very similar to the buyer's contract, but with the listing in this environment, in this market, I'm probably only doing a 3 or 4 month listing. But in any sort of given market, I do try and grab either 6 months to a year. Computation period of days. You're going to see this clause in multiple different documents as we go. And what this states is that if any dates or deadlines in any of these documents fall on a weekend or holiday, they're going to proceed to the next business day. Like I said, we kind of talked about it up front. I'm going to be working with you as a buyer's agent throughout this contract and this time. But I do have the right to work with you in different capacities. And so I'd like for you to read through section 4 and ask me any questions you have on any of that. But we pretty much explained all of it above. Section 5 and 6. What this is this is my duties to you. This is what I should be going through and doing with you throughout the entire process. Now, we kind of already talked about the selling process when we sat down the first time. So go ahead and read through section 5 and 6 and let me know if you have any questions. You will note in section 5.8, I marked the box will. When asked, broker will disclose to prospective buyers and cooperating brokers the existence of any other offers. So Mr. or Mrs. Seller, I'd like your permission right now to disclose to other prospective buyers that may want to make an offer what kind of offers we have in hand and where they're at price-wise. Now, I'd like to do that, Mr. and Mrs. Seller, because I believe that it gets you more money. And what I want you to do is I want you to kind of envision a scenario around this. You see, there's a lot of older school agents, if you will, that do not disclose where properties or contracts are coming in at. And I don't feel like that gets the sellers the most amount of money. And here's why. Let's say you're a buyer and let's say you have a budget of $500,000 and we look at a property for $475,000. and we learn that there's multiple offers. There's 2 offers on the table, and you guys are willing to basically beat the next offer, but the other side's not telling us where those 2 offers are at. What kind of offer are you looking to make? You see, if you're in that situation as a buyer, you're kind of going in blind. And let's say you offer 460 because you feel like that's a great price, and that you would pay that for that house. But then 30 days later, we find out that it sold actually for 465, and you're bummed out now because you would have paid 466 all day. That means that that seller just lost out on a potential $1,000. And so if we have offers that come in, I'd love your permission to disclose to the other side where those other offers are coming in at if they ask. And what that means is if we're on the other side of it and we know we have an offer at 465, then I'm going to go back to that buyer who's thinking about making an offer at 460 and educate them that we're at 465, and maybe they make us an offer at 467 or 470. You see, I think it helps you get more money for your property. Does that make sense? Great. Section 7, compensation. So kind of the opposite of when you bought this house. So when you bought this house, I'm gonna pretty much be positive that you did not pay your agent any sort of commissions. And so unfortunately, on the selling side of things, you pay for both agents' commissions. And so my business, I do charge 6%. And what I do is I pay out 2.8% to the other buyer's side. Any questions around that? And this is where you guys might get objections, right? And sometimes you guys have already discussed this. Sometimes, let's just face it, right? Sometimes sellers want to have the commission conversation over the phone before you even go out to their property. Sometimes sellers want to have commission conversations at the listing appointment before you even have a chance to review this document. Oftentimes in my business, I've already talked about commissions. I'm now simply showing them where it's at in the contract. I have found that if you talk about commissions verbally and they're not looking at a document stating it, I get less objections. But let's pretend that we get an objection right here. Hey, Bruce, I see you charge 6%. Can you do 5? My response typically is I could do 5, but my business does 6%. Are you worried about what you sell the house for? Or are you worried about what you pay me? And like I said, 99% of the time they say, well, I'm worried about what we sell the house for. Great. You see that 6%, that doesn't go to me. 2.8% goes to the buyer's side and 3.2% goes to me in the brokerage firm. You see, I have to pay business expenses, taxes, all of those things. And so what I'd encourage you to do is look back on your last paycheck and see what you actually made and what you brought home. Unfortunately, there's a cost of doing business. And so I wish that I got all 3.2% of this. But the fact of the matter is I don't. My business actually might net somewhere between 0.8 and 1%. And a lot of that's because a percentage of that usually goes to my brokerage firm. Another percent of that goes to taxes, and then taxes and some marketing budget. And so I don't even get to take home a full 1%. So that's why I'm at 6%. Is this going to cause us to stop right here, Mr. and Mrs. Seller? And I just throw it right back in their court if they object. I don't do any. I know the fluffy scripts and ways around it, but I like to break it down by 1%. I got to pay my brokerage firm. I got to pay my taxes. I got to pay a marketing budget, and I get somewhere whatever's left over. And then when they see that, if they still say, well, I'm sure there's something we can cut out, then I simply reiterate, well, I don't know if you know the IRS, but they're not going to let me cut out my taxes. That they're just not going to do that. Number 2 is I work for a multiple person firm. I work for Keller Williams. You do want to be nationally protected by a national brokerage, right? You see, I can't get around that fee either. The only fees that I can get around, Mr. and Mrs. Seller, are marketing budget for your home or what I take home to my family. And you see, I don't know about you, but I don't think you ever go into work and decide not to clock in that day because your boss wants to save on payroll. So I unfortunately can't just work for free. So the only other thing that we're left with, Mr. and Mrs. Seller, is your marketing budget. You see, I pride myself on selling your home for top dollar, and I'm only able to do that if I can spend a bunch of money on getting your home marketed on the internet, door knockers, flyers, calling, open houses, signs, lock boxes, you name it. If you'd like, I can cut that out, but I just don't feel like we're going to get the most bang for your buck. What would you like to do from here? I've learned that if you try and beat around the bush too much, they're just going to continue to ask you to reduce your commission. Be direct, be stern, and stick to your business, right? Did you guys ever, go to your doctor, get the doctor bill, and then decide to try and negotiate it? If you do and it works, great. But if you want to continue to see your doctor and you're continuing to negotiate their fees, guess who's going to drop you? Your doctor. Same thing with an attorney, same thing in every other profession. So be the professional and get your due commission. I promise you it works. And anybody that I've ever had beat me up and not work with me, I can already tell and sniff them out at the listing appointment that they are going to be massively difficult throughout the entire transaction. And so now you've got a more difficult client, more headaches, a harder transaction to go through for less money. It's all about that cost analysis. I don't think we actually said this throughout when the TC people were on here, when Brittany and Savannah were on here. You guys got to get paid for your services, right? And the TC service is very, very cheap. You guys, that TC service is a tax write-off, right? It feels like it's money out of our pocket, but the reality is that you're going to pay that in taxes anyways. So when you go through your listing agreement and you go through this, get your due commission. In this market, I'm probably going to tell you guys to, maybe take some things that maybe we wouldn't. But if you are setting up your conversations correctly, you understand your scripts and you understand how to go through documents and do a seller's presentation, you're going to get your percentage. 6% is not standard. We need to precurse with that too. That's Bruce's business. I've got agents that do 6.5%, 5.5%. I know people that do 7%. Heck, Rich up in Fort Collins, he does 10% on commercial, 7% on residential. Commissions are negotiable. Figure out what works in your business and stick to it. Mr. and Mrs. Seller, you see, I don't charge you anything outside of that. There's no retainer fees, hourly fees, admin fees, none of that stuff. And so you actually don't pay this unless I successfully close on your home, which means you get to choose what offer you accept. And so whatever offer or price you accept, just know that it's going to be minus this commission here. Okay, great. Let's move on. Section 8 says limitation on third-party compensation. Again, through this contract and through this transaction, I'm going to recommend people to you, such as the title company. You see, you have the right to choose whatever title company you want to use for this transaction. I personally use XYZ title company because they get the job done. It's illegal for them to kick back money to me just to use them. So I recommend XYZ title company because I know they get the job done. So throughout all of this, just know that whoever I recommend, I'm not getting any sort of kickbacks. Make sense? Fantastic. Other brokers, assistance with multiple listing services and marketing. The seller has been advised by the broker of the advantages and disadvantages of various marketing methods, including advertising and the use of the multiple listing service, and various methods of making the property accessible by other brokerage firms to use their lockboxes, set appointments, showings, etc. And whether some of these methods limit the ability of another broker to show the property. After having been so waived, seller has chosen the following. You guys want to stop and you guys want to make sure your buyers or your sellers understand this, right? Mr. and Mrs. Seller, we're going to be listing your home on the multiple listing service. Photos are going to be populated. We're going to have all of that happen. When buyers come into your home to see it, they're going to be with their broker. I'm not going to be there, right? Your address will be displayed on the online for all to see. Same with photos. So when we do photos, we need to take down any personal effects that you don't want to have shown online. Any questions about this? Great. Do I have your permission to let in obviously actively licensed real estate agents, licensed appraisers? And here's the thing that I want to talk about. In the state of Colorado, Mr. and Mrs. Seller, inspectors are not licensed, they're certified. And so I would like to let unlicensed inspectors into the home so that way they can get their job done for their buyer. If we don't select this box, Mr. and Mrs. Seller, I'm going to have a hard time finding a buyer who's not willing to have an inspector come through their home. Does that make sense? Great. Now I will vet that inspector. I'll make sure that they're certified, but it is the buyer's right to have whoever they want inspect that home, and so we should give them that right to get into that property. Great. Broker marketing. So this is where I'm not really role playing, but this is where I would put in, pictures will be done on XYZ date. House will be listed on the MLS by XYZ date and time. Showings will begin on this time. And then here's this caveat, right? Have you guys seen in any listings where they say showings start on Friday, we're gonna let it show throughout the weekend, and we're gonna review offers on Monday and Tuesday and get back to the winning buyer? They're able to do that because in their listing agreement under this section 931, you want to make sure that you put in there, seller requests the property to show through XYZ weekend, and we'll review all offers on Monday into Tuesday or whatever you guys set up. Make sure that those words are in here, and then you can put them on the MLS. If you don't have those words in here and you put it on the MLS, you probably, if you start to receive some offers, you probably better get some written communication from your seller through a text message or email that says they want to wait to review that offer until Monday. Everybody see that difference there? This creates writing, an agreement from the seller to wait the weekend. If you don't have it in there and you get an offer on Friday with a deadline of Saturday, you need to present that offer, and you and your sellers need to go through it. Unless they tell you, hey, call that other agent back, have them resubmit their offer for Monday. You want to get those types of communications in writing. Questions on broker market? That's pretty much all Bruce uses for this. I don't do a bunch of fluffy, like we're going to take photos and we're going to have 35 photos uploaded to the MLS, and I'm going to make sure that this is syndicated through our KWLS, and it's going to be going throughout the entire world. I just talk about it. Broker marketing for me is the commitment of dates, and I use dates here because it really puts that timeline in a seller's head, and they seem to execute their timeline better than if I don't put dates in there, right? When you guys get listings, they get all excited and they think they can have the house ready. They think they can get everything done. They think that they can get the whole house packed up. And then they start to push the timeline back. And next thing you know, they end up selling their house down the road from when they really wanted to. Dates psychologically make the seller act and abide by them a little bit more. Section 10, seller's obligation to broker, disclosures, and consent. What this says is that we're going to keep negotiations and communications between me and the seller. Advertising. Seller agrees that the advertising of the property by the seller will be on internet, print, and must be approved by the broker. Meaning, we can't have our sellers type up their listing description to us and just use it because the seller wrote it, right? The sellers don't know how to not discriminate when they describe their home. If you have a seller that says, hey, Bruce, I'm going to go ahead and type up a bunch of stuff about my home for me, 99% of the time, if they have a family, some sort of way, shape, or form, they put This is a fantastic family home. Well, you're discriminating at that point because that's familiar status. You can't discriminate on that. That can't be in your listing description. So if your sellers want to type up their listing description, you need to let them know right here that you may need to tweak or change some things that are compliant with the MLS rules and the commission rules. Make sense? Cool. Ownership of materials and consent. Mr. and Mrs. Seller, like I said, I'm going to be paying for all the marketing material, information, MLS, as well as photos. Those are my material possessions. I'm able to retain them and do what I want with them for marketing purposes to get your home sold. Questions so far? Great. Are you in foreclosure? Are you in jeopardy of foreclosure? Have you received any notices? Fantastic. Let's move forward. Mr. and Mrs. Seller, I've looked at your house and I've walked around it, and I believe that your house is in a condition in which could accept all and pretty much all loan types. So with your permission, I'd like to be able to accept cash, conventional, FHA, and VA loans. Do you have any objection to that? Great. I don't think we're going to have to pay any loan discount points or anything like that to a buyer, so we're going to leave this blank for today. But if your property isn't selling, we may have to get strategic, and we might have to rediscuss what loan discount points are to a buyer. Earnest money, like we said, it's about 1% of the purchase price of the property. We're going to list your house at $550, and so let's ask a buyer to submit $5,000 in the form of a check to the title company. Mr. and Mrs. Seller, as far as your proceeds go, how would you guys like your proceeds? Either a cashier's check or wire? If with your permission, I'd like to just select both boxes, so that way at the end, you guys can make that decision. Mr. and Mrs. Seller, I need to understand if you're a foreign entity right now. Do you happen to be a foreign entity? Because if you are, you may be subject to FIRPTA tax. So FIRPTA is the Foreign Entity Protection Act. And what that states is that if you're a foreign entity and you sell, the government, again, we can't get around taxes, and either would you. So if you are a foreign entity, we need to go through that proper procedure, so that way you know exactly what you'll be taxed. Colorado withholding. This is interesting. I want to read this aloud. The Colorado Department of Revenue may require a portion of the seller's proceeds to be withheld after closing when the seller will not be a resident in Colorado after closing, if not otherwise exempt. I get this question a lot. If you're selling a house and that person is moving to another state, are they charged with a tax? Carson's saying yes. Explain.
Well, aren't they, isn't it like either 2% or I forget the number, whichever's less on that if they're not going to be living here anymore, right?
Could be. And that's why I ask. It was more of a trick question. It says right there, the Colorado Department of Revenue may require. What I believe to be true is that it depends on what state you're actually moving to. I know in California, it's a strict percentage. In Colorado, it happens sometimes, and I think it depends on the reason. I think it depends on where you're going, what other state you're going to, how long you've actually lived in the state of Colorado. Anyways, the end and be all of that is, well, actually, I'm not 100% sure if you will or will not be taxed and what percentage you're taxed at. I need you to go ahead and talk with your CPA. And you'll see down here in section, I forget what it is, but Mr. and Mrs. Seller, it says down here that you have the right to ask for legal and tax advice. And that's where I need you to do that. You see, I'm able to practice limited law, which is these contracts right here. I don't have my CPA license, and so I can't really answer that for you, even if I'm 99% sure. So let's go ahead and talk to your tax advisor. So Carson, I know that your wife is entitled. So no matter how much you know, don't do it because of your license, because you're not supposed to interpret it. I think it's like 1.8% or something like that. Deposits. Brokerage firm is authorized to accept earnest money deposits received by broker pursuant to the proposed contract of the sale of this property. Brokerage firm is authorized to deliver earnest money deposit to the closing agent, if any, at or before the closing of the contract for the property of this for the sale of this property. What this is saying, Mr. and Mrs. Seller, is that once this buyers go under contract, they're going to submit an earnest money deposit. That's just a deposit. It means that they have rights in the contract to receive that back. So we all need to abide by dates and deadlines. And that deposit is going to be held by a third party. Our brokerage firm does not hold that. We actually require that our buyers hold it within a title company. And then they'll hold that for the buyer until we get to close. Not something you totally have to worry about, but I just want this is in here because you're not going to literally receive the check or the earnest money from the buyer. It's going to be held by the third party title company. Great, let's move forward. Inclusions and exclusions. Mr. and Mrs. Seller, let's go over this right now. What kind of appliances are you leaving? And what else are you going to be taking? We need to talk about what's attached to your home. If you have anything attached to your home that you want to take with you, we need to specifically exclude it in exclusions. So tell me, what are you leaving at the property? And I'm going to sit here and type it in as they talk. Do not put it in section 13.13, put it in 13.1.4. This is included with the purchase price. Now you have to be careful here, right? If they want to leave a motorcycle at the property and include it with the purchase price, you're not going to want to put it in here. That technically needs to be done on a bill of sale because a motorcycle has no relation to the function of a home. So that's why we can put appliances in there, because they contribute to the value of a home. A motorcycle, a boat, a trampoline, a hot tub, a playground, those don't contribute to the value of the home. They're stuff. They don't contribute to the functionality of the home. Does that make sense? Cool. So put appliances down here, any special one-off things up here, and this is where you're going to have to do a bill of sale. Anything that's being excluded needs to be listed here. So again, make sure you guys understand this point really, really clearly. If your sellers have TVs mounted on the wall, it's considered fixed to the property. If they want those TVs and TV mounts, it needs to be listed in exclusions. If you don't list it in exclusions and it's not listed in inclusions, it's automatically assumed included, and the buyer can fight you for that. And if you don't have that specifically excluded and you take down that TV and the buyer does their walkthrough and delays closing because you took their inclusions, they have the right to do so. So Mr. and Mrs. Seller, is there anything in your property that's attached to the home that you will be excluding? Rose bushes, plants, TVs, mounted things on the wall. Now I'm not talking about photos because those aren't mounted, they're just hung, meaning I can take them off. I don't need a tool. Mr. and Mrs. Seller, envision that your house was turned upside down and shaken. Everything that falls out is your property. Everything that stays attached to the house is the buyer's, unless we specifically exclude it. So then I go through and I exclude whatever they need to. Can you guys still hear me? Cool, my buzzer died. Parking and storage facilities, I see you have a 2-car attached garage. Are you guys leaving the shed out back? Is there a building, an outbuilding, whatever that is listed here? If you guys have a property that is, on water or septic, just kind of gloss over it for this video and give your coach a call. We're not going to go through that on this video. Most properties are lot and block with just city water. Section 14 says that you will remove any liens and encumbrances off of this title before transferring it to the buyer. I'd like to ask you guys to transfer it to the buyer's name in the form of a special warranty deed. If you need to know what a special warranty deed is, let me know. I'll have the title company send over it, or I'll send you their link to their website so you guys can interpret exactly what a special warranty deed is. Evidence of title. Again, you must furnish this to the buyer free and clear of any liens or encumbrances. Do you guys have an HOA, and what are those dues? Possessions. Mr. and Mrs. Seller, are you going to be out of this home 100% moved out by the time we close, or do you need some time after closing in order to get out of your home? For all of you guys on video right now, section 17 says DOD. It's called delivery of deed. It means once the deed is transferred to the Vital at the time of closing, the seller is 100% out and the buyer has full possession rights to the home. Material defects, disclosure and inspection. Mr. and Mrs. Seller, anything that you tell me or anything I can see in which I find to be a material defect of your home, I have to disclose to the other side. So right now, is there anything that we need to disclose to the buyer's side in order to keep you out of litigation down the road? Because if you hide something from the buyer and they can prove that you had prior knowledge of it, they can take you to court and sue you for that. So if you know of something that's wrong with your home right now, let's disclose it to the buyer versus paying for it down the road. Do you guys have any questions on material defects? Okay, if you guys articulate it that way, they'll start to tell you about their house, or some sellers just shut up and still hide it, but at least you had that conversation. Never, ever, ever hide anything that you already know about that property. Mr. and Mrs. Seller, we need to make sure that you have carbon monoxide detectors in code required places. If you do not, this will get flagged on inspection as well as the appraisal. It's state law. We need to have CO detectors in place. This house that I'm selling is not in the lead-based paint form, but Mr. and Mrs. Seller, your house was built before 1978, and that actually requires a lead-based paint disclosure form, which we'll go over in a little bit. But do you guys have knowledge of lead-based paint in your home? Hopefully they say no. And then on that form, you're just going to select buyer has no previous knowledge. Condition of the property. Mr. and Mrs. Buyer, we need to convey this property in as good or better condition to the buyer at the time of closing. And what that means, Mr. and Mrs. Seller, is that you need to continue to mow your lawn. You need to continue to upkeep the property. If you break a window because you were moving your dining room chair outside and a leg just happens to kick the window out, you need to get that replaced. If you guys have a flood, we need to call the insurance company. This property must be in as good or better condition to the buyer when we go through this. Is that going to be an issue for you guys? Great. Section 19, you have the right to cancel this agreement with me, and I have the right to cancel this agreement with you. And the only way that I can really see myself canceling this agreement with you is, one, if we're not abiding by the dates and deadlines in the contract and I can't get a hold of you. You guys need to have communication with me as we go throughout this. Two, if we list your house at 550 and I get an offer for 550 or more, technically you have the right to decide whether you accept it or not. If you don't accept an offer at 550 or more, I'm going to have a hard time believing that we are representing each other in good faith, because you're signing this agreement saying you're willing to take 550. So if another offer comes in and everything looks good and you don't want to take that, I may have to decide whether I need to cancel this agreement or not, because I'm here to do a job and I'm here to get your home sold. And at that point in time, I'm going to have a lot of marketing dollars in this. And I need to decide whether I need to continue to spend that marketing dollar, because I'm going to be at a loss for words if you're not willing to accept a price in which we are agreeing upon today. And vice versa, guys. You guys can cancel me. If I'm trying to educate you on taking a $500,000 offer just because I want to get paid in a quick, timely manner, you guys are going to have the right to fire me too. If I'm not doing what we set forth in section 4 and 5 and 6 in this contract, as your agent, you have the right to cancel this contract with me. All I need you to do is send me a text message or email or some form of writing that releases me from this, or that requests that I release you from this. Does that make sense? Great. Forfeiture of payments. What this really says is that if we go under contract with a buyer and that buyer backs out of the contract and they do not have the right to retain their earnest money, I don't collect any of that. I'm gonna forfeit it right to you. Cost of services and reimbursement. Throughout this contract or throughout this dealing, if you hire somebody, you pay that service provider. I can't pay the title company for you. I can't pay to have a contractor come in and do all of this stuff. Cost of services will be with you. If we do renegotiate, and I do, if I am willing to pay for maybe a repaired item, I'm going to have you pay for that repair, and I'll pay you back in the form of a commission reimbursement at closing. Does that make sense? Great. So I want to break that down for you guys a little bit. I know we got about 5 minutes. We're almost done with you guys out of here on time. There are times where I want a seller to, if they have knowledge that there's a high radon system or high radon, and I want them to put the radon system in for the buyer, they pay for it. And then if I want to, I'm willing to reimburse them $1,000 at closing. Sometimes I know that putting in granite countertops is going to be the difference maker. So I'm going to educate the seller to maybe put in granite countertops. And if that gets them more money, I might be willing to split that cost with them or something like that. So that's what reimbursement and cost of services kind of breaks down to. Cool. Disclosure of settlement costs. Like I said, any party to this contract or this deal that you hire, such as the title company, they must disclose their cost and their price to you. So anytime that you guys need to know what you guys are spending money on, please ask me. We'll ask the title company. We'll ask any service provider because they must disclose what that service cost will be. Maintenance of the property. So kind of like what we talked about up top here, where we have to have the condition of the property in as good or better condition. Maintenance of the property. You must keep mowing your lawn, right? I will not mow your lawn. I'm not going to come over and paint some trim, and I'm not going to come over and change out your toilet. So if things happen during this time, you need to have those fixed so that way we can convey the property in good condition. Non-discrimination, all right? We cannot discriminate on the buyers that we have come forth. A buyer's contract is a buyer's contract regardless of their race, sex, or creed. You cannot not accept a contract because you don't like families and you find out that the buyer who submitted this contract has kids. Does that make sense, Mr. and Mrs. Seller? Perfect. Let's move on. Like we said earlier, recommendation of legal and tax counsel. What this says is that you have the right to have all of these documents reviewed by an attorney. You have the right to hire a CPA. Because you're a foreign entity, I'd recommend that you do hire a CPA. Because you are moving out of state, I do recommend that you hire a CPA. Because this was an investment property, I do recommend that you hire a CPA. I really want you to know your tax implications, Mr. and Mrs. Seller. If we start to butt heads, we go into mediation versus the courts. Any attorney fees will be the winning prevailing party, or will be at the expense of the losing party. Sorry. I don't have any additional provisions. I don't have anything wordy or fluffy to put in here for you. I'm a pretty straightforward guy, and I want to get your home sold. Section 31 states that we can sign electronically. Section 32 says that if we modify this contract, we need to do it in the form of an amend extend signed by both you and I. Any questions? Perfect. Once we sign this, I'm going to send you a copy of this contract and we can move forward, and I'll get that sign and lockbox over to you. We'll get photos done, yada, yada, yada. Questions? All right.